So good morning, everyone. It is rather early in England and just about the right time to start in France. We thought there would be interest on both sides of the channel for a topic on jurisdiction issues post-Brexit. We will leave aside conflict of laws issues, which have to some extent been solved by the UK, which incorporated the Rome I and Rome II regulations on the law applicable to contractual and non-contractual obligations into English law. We will focus on jurisdiction issues and what type of opportunities or hurdles the Brexit creates for cross-border litigation. To discuss this topic, I would like to introduce briefly your panelists today. So Joanna Pearson, a partner at Humphries Kerstetter with 20 years experience in complex financial services litigation and regulatory investigation. Joanna was a partner at Simmons & Simmons before she joined Humphries Kerstetter. Many of Joanna's matters have an international element, so that's the reason why she was chosen as a panelist today. Chris Kerstetter is the founder of the firm that bears his name. He's an international disputes lawyer who's qualified both in the US and in the UK. He worked at Linklaters before joining Humphries Kerstetter, and he has particular expertise in international arbitration. On our end, Denis Moralis is of counsel at Le 16 Law, but more importantly, a distinguished law professor at the University of Aix-Marseille. He's also an attorney at the Paris Bar, and he specializes in arbitration law and private international law. As for myself, like Chris, I'm qualified both in France and in the US. I've been practicing as a litigation lawyer for the best part of the last 20 years at international law firms. And I joined Le 16 Law, a dispute resolution boutique in Paris 4 years ago. As for today's topic, let me start briefly. As our English audience will know, but the French one less so, the Brexit transition period or implementation period is the period agreed in the UK-EU withdrawal agreement. The transition period started immediately after the UK left the EU, and it started on 31 January 2020, and it ended on 31 December 2020. During this transition period, the UK was no longer a member of the EU, but remained a member of the single market and customs union, and it continued to be subject to all EU regulations. However, since this transition period has ended, since 1 January 2021, the EU regulations in place no longer apply in the UK. This is unfortunate because the prior European regime, which applied in the UK, is quite comprehensive, and it aimed at providing rules to limit or prevent conflicts of jurisdiction. It also aimed at preventing conflicts of laws and at ensuring that EU judgments would be easily recognized and enforced in all member states. Just focusing on the EU regulation 1215/2015, i.e. the Brussels I recast regulation, it provides jurisdiction rules to prevent jurisdiction issues and rules on the recognition and enforcement of judgments in civil and commercial matters. It also aims to make the circulation of judgments in the EU member states easier and faster. What happened under the recast version of the EU regulation, what was known previously as the exequatur procedure to recognize and enforce judgments in EU member state has been abolished. This means that a judgment given in one EU country is recognized in other EU countries without the need for any special procedure. The Brussels I recast regulation also improves the effectiveness of choice of court agreements. It gives priority to the chosen court to decide on its jurisdiction, regardless on whether it is first or second seized. Any other court has to suspend proceedings until the chosen court has established or declined jurisdiction. This is the main regulation that was applicable and which is relevant to our topic today. Obviously, there were a lot of EU regulations providing rules to solve conflict of jurisdictions and conflict of law issues, and we can name the EU regulation on insolvency proceedings, for example. Overall, the EU regulations provided a body of rules which gave certainty to litigants in the EU member states, and the fact also that the ECJ case law was binding on domestic courts also participated in ensuring certainty to litigants in the EU member states. I will now turn over to Joanna. Jo, can you explain to us what is the current legal framework post-Brexit?
Thank you, Alexandra. Yes, absolutely. So I think we had all been waiting before Christmas to see whether there would be a equivalent reciprocal regime introduced. And I think probably we thought there might, but as with financial services equivalents, that didn't make it into the final trade and cooperation agreement agreed before Christmas. Instead, what we're left with is a real patchwork of existing regulation or existing regimes, and then sort of the traditional old rules that existed prior to the European regime. So the only main convention that there is that applies to jurisdiction and recognition and enforcement of judgments that remains is the 2005 Hague Convention on choice of court agreements. The UK had been a member or a signatory, we'll get onto this actually, this is a fairly contentious issue, but the EU certainly has been a signatory to the Hague Convention on Choice of Court Agreements since 2015, and obviously the UK was a member of the EU at that time. The Hague Convention relates to jurisdiction agreements, so it is choice of court agreements, and it regulates what happens in relation to jurisdiction and enforcement in the context of those choice of court agreements. So the key point about the Hague Convention is that it only applies to choice of court agreements, and on definition, when you look at the terms of it, only to exclusive choice of court agreements. So it is automatically much narrower than the previous regimes. It also obviously means that if you don't have a jurisdiction agreement in your contract, or that you have a different type of jurisdiction agreement, so for example, a non-exclusive or an asymmetric clause, the Hague Convention won't apply. We're going to come on and talk about asymmetric clauses a little later on in more detail, but in summary terms, these are clauses where one party must sue in a particular jurisdiction, but the other party, usually the financial institution, can sue wherever it likes. And so there is an imbalance in the clause as to where parties are entitled to pursue proceedings. But those, it's fairly settled, aren't covered by the Hague Convention. So what is covered? Well, as I said, exclusive choice of court agreements are covered. So if you have one of those clauses, Article 6 of the Hague Convention requires another court, so your non-chosen court, if proceedings are commenced in that court, it requires that non-chosen court to stay or dismiss proceedings. So for example, if you have an English exclusive jurisdiction clause and your opponent commences proceedings in an EU member state, the courts of that EU member state should, in theory, suspend or dismiss the proceedings and defer to the jurisdiction of the English court. I say should because there are some specified exceptions in that part of the Hague Convention, again, which we're going to come on and talk about, but deal with sort of exceptions around public policy and manifest injustice and so on. So it's not certain that the other non-chosen court will suspend or dismiss, but probably fairly likely. As I mentioned, there is a timing issue as to when the UK actually became a signatory to the Hague Convention. And this matters because it may mean that even exclusive choice of court agreements that were entered into prior to January 2021 won't be covered by Hague. So if there is a jurisdiction issue between the UK and the EU, and you have a clause that was agreed in that prior period, it may mean that Hague doesn't come to regulate the situation as to jurisdiction and enforcement. Now, there's a debate about this. The UK's firm belief and position is that because it was a member of the EU at the time the EU signed up to the Hague Convention in 2015 and became a signatory to the Hague Convention in its own right on the 1st of January 2021, it has effectively been a member continuously, and so there is no issue. All choice of court agreements should be covered. The EU, funnily enough, takes a different position, and the EU Commission has come out and said very clearly, no, the UK was not a signatory in its own right via its membership of the EU. The EU was a signatory, and it is only from the 1st of January this year that it becomes a party to the Hague Convention in its own right, and therefore choice of court agreements only from the 1st of January sort of are regulated by this regime. This is an issue that will have to be resolved in some way, but I think we certainly anticipate that there may well be disputes around whether the Hague Convention regime applies, and certainly parties who want to create jurisdiction challenges may well focus on this area, and that's an area we're going to focus on shortly. As probably is clear from this, the Hague Convention regime is far from comprehensive and certainly doesn't mirror what was there before. And I think recognising this, the UK has been very keen to sign up to the Lugano Convention, which is a much more comprehensive regime and almost mirrors the prior Brussels regime. There's one very important way in which it doesn't, which we're going to come on and talk about, and the possibility of so-called Italian torpedoes being used again. But it is much better and contains all of those broad sort of reciprocal arrangements regarding jurisdiction and enforcement. The problem is that the EU hasn't agreed that the UK should sign up to it, and its agreement is required. I think there is some hope that that will happen eventually, but it's going to take months for the UK, if there is that agreement, to exceed. And so we will have a period of uncertainty and opportunity for jurisdiction challenges during that period, even if we do get to Lugano. Finally, before I hand back, I was going to just make the distinction between transitional cases and new cases. So cases that are commenced pre and post the 1st of January 2021. And this matters because the treatment from a jurisdiction and enforcement perspective is different depending on whether your proceedings started before or after that date. So for the before period, what I'm calling transitional cases, and that's because they were commenced probably within the transition period, which ended on the 31st of December 2020 or before then. It's clear that the English courts will continue to apply the European regime that was in place, and so particularly will continue to apply the Brussels I regulation recast. And the same goes for judgments that are delivered even now in relation to cases that were started prior to the end of December 2020. So in some respects, for many cases, the position will have been preserved. For new cases, however, obviously it's different. So for cases that are commenced after the 1st of January 2021, either Hague will apply, as I've discussed, so for exclusive choice of court agreements, and that regime will apply. But if it doesn't, we are all dusting off our textbooks and looking back at the old rules. We haven't had to look at them for some time, but looking back at the old rules, what's known as common law rules that cover how the English courts will respond to jurisdiction issues where there is no overarching European framework. And the broad point there, and I'm not going to go into the detail of it, but the broad point is that there are many ways in which the English court might find that it has jurisdiction, looking at all sorts of factors. For example, where the parties are located or where the relevant events have occurred in different types of causes of action, what the likely governing law is going to be. But to counterbalance that, the English courts will also have a discretion to decide that another forum is more appropriate, that there is a closer connection to another country, and decline jurisdiction. So within that sort of common law regime, there's more opportunity perhaps to find jurisdiction, but equally more opportunity for challenges that somewhere else is more appropriate. So handing back now to Alexandra and Denis, who are going to look at some of those potential challenges around jurisdiction.
Yeah, I think it's my turn to speak. I don't want to take away the floor to anybody, but what you say leads us to the question of jurisdiction challenges in within the EU member states. And the first issue we have to address is after this transitional period, what happens if an EU member state is confronted to a jurisdiction clause designating English courts. So I think we should distinguish. I think the first issue is to understand what is the scope of the Hague Convention, because as you mentioned, the 2005 Hague Convention should apply, but its scope has some limits. So first, the Hague Convention applies to all jurisdiction clauses except in some circumstances, and you have to look at Article 2 of the Hague Convention to see all the exceptions, but the most notable ones are contract with the consumer, employment contracts, and carriage of passengers and goods. And in contracts, in those contracts, if there is a jurisdiction clause, the Hague Convention will not apply, meaning that you have to turn to the local law of the court which has been applied to, and we'll take the example of France. And there is another issue which is a bit controversial. It is whether the Hague Convention, as you say, Joe, applies to non-exclusive, or more specifically to asymmetry clauses. What is certain is that the Hague Convention applies to exclusive choice of courts agreements. The question is whether an asymmetry clause is an exclusive choice of court agreement, and I would dare to slightly disagree with you, Joe. What I mean is I'm not totally certain that the Hague Convention cannot apply to an asymmetry clause, but I'll come back to this. So the first issue is if the Hague Convention applies, a French court, let's take the example of France, a French court which has been applied to and which observes that there is a choice of court agreement applicable, and this choice of court agreement designates English courts, should normally, the convention says, suspend or dismiss the proceedings. A French court would dismiss the proceedings, not just stay them. There are some cases in which the French court should not do that. It is if the agreement is null and void under the law of the state of the chosen court, which means English law. So a French court would very simply apply English law as to the validity of the agreement. A French court would check whether, according to the convention, the French court would check whether one of the parties lacked the capacity to conclude the agreement under French law. But there should not be a lot of problems here, because under French law, any adult with legal capacity or any company, any corporation can conclude the choice of court agreement. There is the issue of manifest injustice or public policy of the court seized, which a French court could refuse to apply a choice of court agreement if it is contrary to public policy or if it is manifestly unjust. As to public policy, French law is very, very tolerant towards choice of court agreements in international contracts. There could be the issue of asymmetric clause, but we'll come back to that later. And as to manifest injustice, I don't really see a lot of cases in which this would apply. Maybe, again, we would have the problem of manifest injustice, but in case of asymmetric clauses, but again, we'll come to that. I think the real issue to discuss is the problem of asymmetric clauses. It is difficult to be very specific because we have almost no case law in France applying the Hague Convention, since it has been ratified by almost only by EU member states. So when French courts are confronted to choice of courts agreements, they don't have to apply the Hague Convention, but the Brussels I regulation and its recast. So we can only try to infer some, to draw some conclusions from general principles of French law or French case law. But I did not find any case applying the notions of manifest injustice, for instance, under the Hague Convention. Now, if the Hague Convention is not applicable to a choice of court agreement, for instance, because it is in a carriage of passengers and goods contract, or a contract with a consumer, an employment contract, we have to turn to general principles of French law. So the first principle is that choice of courts agreements are perfectly valid in international contract under French law, according to a very famous 1985 case. But in consumer contracts, and this is important because it is one of the very important, the big exceptions to the application of the Hague Convention. In consumer contracts, EU consumer law applies, and choice of court agreements are presumed to be unfair under French law under the 1993 directive. And as you probably know, the European Court of Justice has decided in several cases that those clauses are unfair even when they designate a court of the country in which the consumer resides, if it is far away from the domicile of the consumer. So I guess that in a consumer contract, to summarize and to be very clear, in a consumer contract, a clause designating an English court would, I think, not be applied by French courts, not because of the Hague Convention, but because of French and European law, as long as the consumer is domiciled within the European Union. I turn now to asymmetric clauses, and they pose a series of questions. First, the first question, as Joe said, is whether those asymmetric clauses apply to, or whether the Hague Convention applies to asymmetric clauses. The question must be addressed because, or there is a question, there is an issue, because the Article 5 of the Hague Convention provides, I quote, "The court or courts of a contracting state designated in exclusive choice of court agreement shall have jurisdiction," etc. And in Article 3, you find a definition of exclusive choice of court agreement. It means, I quote, "an agreement concluded by two or more parties that meets the requirements of paragraph C," meaning in writing, "and designates for the purpose of deciding disputes which have arisen or may arise the courts of one contracting state or one or more specific courts of one contracting state to the exclusion of the jurisdiction of any other court." Now, as I understand it, in fact, the question of whether the Hague Convention applies to asymmetric clauses is an English preoccupation because of the Brexit, and English lawyers and English courts have become very interested in the Hague Convention and its scope. And there are a few cases that our British friends know much better than me, but there are at least 3 cases in which the question was addressed, but I think as obiter dicta, because those cases were concerned with the application of the Brussels regulation. So some English courts have doubted the applicability of the Hague Convention to asymmetric clauses, but I don't think those opinions are unanimous. So it's not very clear. As I understand it, if we think about the situation of the party which has to apply to a specific court, an asymmetric clause remains an exclusive choice of court agreement. French courts have never addressed this particular problem, again, because they don't have the opportunity to apply the Hague Convention. Maybe they will now. Anyway, I think that whether the Hague Convention applies or not would not change the decision of a French court. Let's imagine that we have a contract, probably a finance contract, in which a client is compelled to apply to English court in case of a dispute, and a bank has the choice of to apply to any competent court. In the current state of French case law, such a clause would be applied and would be respected. If we apply the Hague Convention, French court must respect the clause according to the Hague Convention and could only refuse to respect the clause if it is manifestly unjust or contrary to public policy. If we apply French law, such clauses must be applied, must be respected, except in consumer contracts. But if we're not talking about a consumer contract, it should apply, except, of course, if it is contrary to public policy. So what do French courts say about asymmetric clauses? At the beginning of the 2010s, they were quite reluctant to give effect to such clauses because they were seen as totally unbalanced. And in a 2012 case, the Court of Cassation said that such a clause is in fact a clause with a potestative condition. So this is a very civil law notion. But the idea is in such a clause, you have a condition a condition precedent, which is met or not only according to the will of one of the parties, and such conditions are not valid. But later, the Court of Cassation changed totally its approach. In 2015, it said that that asymmetric clauses are valid as long as there are objective criteria designating the court, the party which has the choice can apply to. And in 2017, it rendered a decision which is even more liberal, and which says that asymmetric clauses are perfectly valid. And in this case, the clause say that one of the parties had to apply to an Italian court, whereas the other could apply to any competent court, and this was considered as valid. So if you apply the Hague Convention I don't see why a French court would use the exception of public policy or manifest injustice. And if you don't apply the Hague Convention, I don't see why a French court would not give effect to an asymmetric clause. But again, we have to reserve the case of consumer contracts. In consumer contracts, choice of courts agreements are considered as unfair, or it's a presumption, but it seems very difficult to rebut it. And asymmetric clauses would be even more unfair because they create an obvious imbalance between the rights and obligations of the parties. I hope I was clear, but of course I'm available if there are some questions later.
Thank you, Denis. I think that was very clear, at least to me. Let's now turn back to the Lugano Convention. As mentioned by Joanna, the UK has applied to accede to the Lugano Convention, but we don't know when that will happen. But if the UK does accede to the convention, this Lugano Convention will govern questions of jurisdiction and of recognition and enforcement of judgments in civil and commercial matters between the UK and all the current contracting parties to the convention, that is, namely the EU member states, but also Norway, Iceland, and Switzerland. The effects of the convention are very similar to the recast Brussels regulation, or rather, the previous version of the Brussels regulation. There is one advantage or a disadvantage, depending on your perspective, of the recast Brussels regulation, which is its Article 31, paragraph 2, which amended the previous version of the Brussels regulation to put a stop to the so-called Italian torpedo tactic. The Italian torpedo tactic works like this. A dispute arises between parties in relation to a contract that has an exclusive jurisdiction clause. And notwithstanding that exclusive jurisdiction clause, and before proceedings are actually issued in the courts of the chosen EU member state, one party to the dispute brings an action seeking a negative declaratory relief in a different EU member state. So that party seeks a declaration of non-liability. Obviously, as it's a delaying tactic, the member state that is chosen for the declaration of non-liability is usually one with a reputation for a slow and inefficient judicial system, sometimes even with no connection whatsoever to the claim, and ideally, obviously, a court that can issue a declaration of non-responsibility. In this respect, while French courts can be slow and inefficient, French courts cannot issue declaratory judgments, unlike apparently Italian courts. So that is why it's called the Italian torpedo, because the Italian courts are often chosen to that effect. Obviously, the sole aim of such torpedo is therefore to frustrate the other party's claim. Indeed, under the Lugano Convention, the rules require that the court of the member state in whose favor the jurisdiction clause was drafted should wait until the first court seized has decided whether or not it has jurisdiction over the claim. So obviously, if you seize an Italian court and it's going to take 3 to 5 years to get a decision from the Italian court as to its jurisdiction over the matter, you have, in effect, delayed the proceedings by 3 to 5 years. One solution to this issue, but it can also be used as a delaying tactic, is where English courts are the courts chosen by the parties, is for the other party that worries about the other party using the Italian torpedo to use so-called protective claims and seek negative declaratory relief before the English court that has jurisdiction as per the choice of jurisdiction clause provided in the contract. One illustration is a 2020 English case, which is called Master Melt against Siegfried Evianaz, a Swiss company. The defendant against whom proceedings had been issued in England notwithstanding a clause in the contract that conferred exclusive jurisdiction on the Swiss courts, commenced proceedings in Switzerland in accordance with the contractual exclusive jurisdiction. So you had two separate proceedings ongoing. The first proceedings were started in the English courts, and the second proceeding were started in the Swiss courts as per the contractual exclusive jurisdiction clause. One of the parties sought to have a stay of the English proceedings, arguing that the Lugano Convention had to be read in light of the new wording of the recast Brussels regulation, and therefore that it was not for the first court seized to rule on its own jurisdiction. However, the English High Court held that there was no basis for reading the Lugano Convention in this way, and that the English court, as the first court seized, did not have to stay its proceedings pending the outcome on jurisdiction in Switzerland. So, well, this case shows, it's just an example of the type of disputes over jurisdiction that we may see under the Lugano Convention if at some point the UK accedes to the Lugano Convention. Lastly, and before I turn back to Joanna, it is worth mentioning that under the Lugano Convention, there is no obligation for courts to follow the ECJ case law, so that there can be discrepancies in the interpretation of the Lugano Convention by the courts of the signatory states. So these are two examples of the type of jurisdiction issues that we will see if the UK accedes to the Lugano Convention. I understand that now also anti-suit injunctions are back in the picture, and I will turn back to Joanna to explain to us how they work and in which context they can be used.
Probably back, yeah. So I think obviously anti-suit injunctions was something that wasn't contemplated under the prior European regime. But under Hague and more generally, the general feeling is that will become available again. So effectively, it's a mechanism by applying to the English court if you have a jurisdiction clause in favour of the English court seeking to restrain the other party from pursuing proceedings elsewhere. I wasn't going to spend too much time on that. I will briefly mention some of the ways of mitigating the risks we've talked about. I appreciate completely there is, first of all, that English lawyers are fixated on the asymmetric clause issue, and that there is a mixture of views as to whether or not they will or will not be covered. But I think probably, and probably is actually a word that the English court has used in that context to say they probably aren't. It just illustrates the scope for dispute, that opposing parties will take these points because there is uncertainty as to whether, what the true position is. And so with that, there is obviously risk, but also opportunity. Some of the ways of dealing with that are deciding to swap all your contracts to exclusive jurisdiction clauses. The other changes you can make to deal with the timing issue around the Hague Convention and the UK versus EU position is to simply restate your exclusive jurisdiction clauses as of or from the 1st of January to make sure that you're within this current period. So there are things that can be done to mitigate some of these risks, but I think generally we feel there is still some opportunity for parties to make jurisdiction challenges if they would like to create complication for leverage purposes. Moving on though, Chris, I think we're interested in hearing about some alternative dispute resolution mechanisms, arbitration in particular, and also whether the enforcement of judgments landscape has changed significantly in this new strange world.
Yes, thanks, Jo. Well, starting with arbitration, the good news is that arbitration is really not very much affected at all by Brexit. Arbitration is generally governed by a separate treaty regime, the New York Convention of 1958. And that has 168 states as signatories. And the EU countries are signatories to that convention in their own right. So the impact is not very great at all. Arbitration is also carved out of the EU jurisdiction and enforcement regimes. So all the the attractive and unattractive aspects of arbitration remain unchanged. Parties are still attracted to arbitration because of things like confidentiality, flexibility, neutrality, and the enforceability of an award in all of these 168 states. However, when you think about some of the challenges that have arisen as a result of Brexit for court judgments, you might see that parties that are interested in using English law for their contracts or English dispute resolution mechanisms might be more attracted now to the option of arbitration than they might have been before, pre-Brexit. There is one aspect that is an exception to the carve-out in a way, and that is what you just touched upon, which is the anti-suit injunction. Because when you describe the Italian torpedo, you're talking about someone issuing proceedings in an EU jurisdiction, like Italy, for example. If that happens in relation to, in contravention potentially of an arbitration agreement, the English courts were very keen to protect London-seated arbitrations by issuing anti-suit injunctions. But the EU regime did not allow that, and that was set down in a case called West Tankers, which got the London arbitration community very upset indeed. But as you say, anti-suit injunctions are now potentially back on the table and in relation to arbitration as well. So where you have an arbitration agreement for a London seat, the English courts might now potentially be able to protect that jurisdiction against preemptive litigation in other EU member states by issuing anti-suit injunctions. So that aspect might make London a slightly more attractive jurisdiction for arbitration. Before I move on to the aspects of enforcement, I'll just ask Denis whether he has any comment on arbitration.
Well, I don't have a lot of things to add. I agree with you. Brexit does not change a lot of things about arbitration, but the one thing which has evolved is the possibility for English courts to use anti-suit injunctions again when an EU court has been applied to. And if we compare the situation of in which an arbitral tribunal is seated in London or and in Paris, I may not like that, but I have to concede that there is a competitive advantage for the London seat, because English courts will be able to protect the arbitration proceedings against parallel courts proceedings. That being said, I would just add one thing. It is that a French court, of course, cannot issue an anti-suit injunction to stop court proceedings elsewhere in the European Union. That's true, because of EU law and the West Tanker judgment you cited. But I think that French courts could, if they were a bit daring, they could issue anti-suit injunctions to stop state court proceedings outside the EU, including London or a British court. Because if you look at French law, an emergency judge under French law can take a lot of measures. There is not a limited series of measure a judge can take, and French judges can issue injunctions in other contexts. So I think that an audacious French court could at least try to make the French seat a bit more competitive to this extent, but of course it would not be possible if the state court proceedings are opened in an EU court.
Thanks, Denis. Yeah, it will be interesting to see what happens. As with all of these things, most of this will have to play out in future decisions, and it'll be interesting to see whether the French courts decide to up their game, so to speak. But the position on enforcement of court judgments is completely different. That is very heavily impacted by Brexit, and in that sense, we have a very hard Brexit because, as Joe was saying, there hasn't really been any attempt to put in anything to replace the old Brussels recast regime, which dealt with enforcement. So we have no Brussels recast, we have no Lugano, and we don't have any longer the European enforcement order regime for default judgments either. So we're very much falling back on this patchwork of potential local law regimes or domestic law regimes to enforce judgments from abroad. Now, there are three consequences to this. One is that the procedures that will need to be followed to enforce foreign judgments in England will be a bit more complicated, a bit more onerous, and therefore a bit more expensive. There will be potentially types of judgments that will be more difficult, potentially much more difficult to enforce. And I'm thinking there of default judgments or judgments that are not for a money sum. And then there's going to be some additional uncertainty because many of these regimes haven't really been used, certainly in relation to EU countries, for some time. So anyone enforcing a judgment from an EU state in the UK is going to have to confront some uncertainty as to how things will play out. And I'll just take those very briefly. With the procedure, the old Brussels recast, well, it's not old, but it's no longer applicable in the UK, allowed for very wide enforcement of virtually any type of judgment. And you could do so on the basis of a certificate issued by the originating court. And you could use that to go straight into enforcement proceedings in England. Now we have various regimes. We have the Hague Convention that we've discussed. If the Hague Convention does apply, then there's an enforcement procedure under that treaty. And in relation to situations where you have a bilateral arrangement for the enforcement of judgments, England has a statutory regime, the 1933 Act, under which that provides a separate procedure for the enforcement of judgments. And then if you haven't got any of that, you need to fall back on the old common law action on a judgment. So that makes things more difficult for the treaty, the 1933 Act regime. You would need to make a separate application for the registration and the recognition of the judgment before you're able to go into enforcement. And under the common law, you need to bring a fresh action for a judgment on the debt. So you would have to pay the court fees and go through service out of the jurisdiction, etc. So those procedures are more onerous. Now, on the types of judgments that might be enforced, if you have a money judgment, you're probably going to be in good shape. There may be more difficulties if you have a default judgment, because default judgments may not be enforceable under the common law regime, which generally requires that judgments be on the merits. And if you have a non-monetary judgment like an injunction, you may have some difficulty because those are not generally enforceable under the common law regime or the statutory regime for mutual recognition of judgments among states. Now, on the final On the third aspect, the uncertainty, it could crop up in many ways. I'll give you an example, taking France as an example appropriately. If you have a French court judgment after the transition period, for proceedings issued after the transition period, you need to decide whether you want to proceed under the 1933 Act regime or the common law. And that may not be so simple. There is a historic bilateral treaty dating back to 1934, and it's between France and the UK, and it deals with the reciprocal enforcement of judgments. However, the regime, Brussels regimes for recognition and enforcement of judgments amongst EU member states superseded those types of conventions. And there is therefore a question as to whether those conventions will automatically revive, or whether the EU's taking over of competence from member states in this area will prevent that from happening, in which case you would be back into the common law regime. So I see that there's not much time, so I'll end there and hand back to Denny to see whether he's got any comments about enforcement in France or under the Hague Convention, and hopefully we'll be able to squeeze in under time.
Well, no, again, you were quite complete. I think I don't have a lot of things to add. I agree that the application of the 1934 convention after Brexit between France and the UK is very problematic. We don't know whether it is still in force. So if you want to enforce for a British judgment in France after the transition period, unless it is in the field of the 2005 Hague Convention, because the judgment has been rendered by an English court designated by a choice of court agreement, you just have to turn to French law about enforcement of foreign judgments. But the good news is the French rules, despite being only case law rules, we have no statute here. Despite this being case law, French rules are quite clear, and it is, I think, quite easy to enforce a foreign judgment. And in our case, a British judgment, it would be quite easy to enforce it in France. The conditions are clear. The foreign judgment must be, and the judgment should be enforceable in Great Britain first. No French judgment should have settled the same dispute, because then the res judicata of the French judgment would prevail. The English court should have had jurisdiction, but it means that there should be an objective link between the English judgment and the case. The British judgment should not be contrary to international public policy, but French courts have a very limited notion of international public policy. It's not at all the same thing as French domestic public policy. And then the application to an English court should not be a fraud. The parties should not have attempted to escape the application of French court jurisdiction. So I think there may be less uncertainties as in Great Britain. The case law is very well known, and it should not be too complex to enforce British judgment in France.
Yes, thanks, Denis. It's probably worth mentioning that list that you just gave is quite similar to the criteria for enforcing under the common law regime. So if you've got a money judgment, I think you're in pretty good shape in England as well, if it's a money French judgment.
Okay. I don't think that we have exhausted the topic, but I know that we're running out of time. If there are any questions in the audience, now is your time to raise those questions. And if you are shy, well, then we're available offline for any questions that you may have on this topic. Either Joe and Chris or Dennis and myself. So
Alexandra, I think there is a question on the question and answer chat.
Oh, yeah.
I think it is for you. Is there a way to circumvent the Italian torpedo risk?
Is there a way to circumvent the Italian torpedo risk? Yes, well, I think I touched upon this a little bit, and the only way is to be the first one to seize a court. So the way to circumvent the Italian torpedo is to, when you know that you're in a dispute with another company and you fear that they may use some kind of delaying tactics such as the Italian torpedo because they wouldn't want a judgment against them. Well, the idea, if you have an English jurisdiction clause, is to seize immediately the English court and seek a negative declaratory judgment. You may also, that's one option, you may also seize first, you have to seize first the court that has jurisdiction under your contract. That's the best way as the first court seized is the one that is going to be entitled to rule on its own jurisdiction, then the idea is to be the first one in the race. I don't know if you have anything to add to this.
No, just to say, I mean, that was what people did before the Brussels regulation was amended to sort of mitigate, you know, not allow people to do that.
Yeah.
So it just means that timing and as soon as you know that you have a dispute brewing with a party that is likely to take that sort of action, you know, contrary to your jurisdiction clause, you know, obviously get advice and think about whether you want to be proactive in protecting your position.
Yeah. In this respect, under French courts are not allowed to grant declaratory relief. So you cannot apply to a French court to seek a declaration of non-liability. That is not allowed. I think there are no more questions. So I think we'll call it a day. Again, do not hesitate to contact us offline if you have questions. Thanks to Joe, thanks to Chris, and to Dennis. Thank you very much.
Thank you.
Thank you.
Have a good day.
Bye-bye.
Bye.
Bye.